Elon Musk did not sue OpenAI because he lost an argument. He sued because he believes something was taken, not from him personally, but from the original agreement that justified the entire enterprise. Whether that belief is sincere or strategic is a question worth holding. But the lawsuit itself forces a question that the AI industry had been carefully avoiding. Can a company founded to prevent an AI catastrophe survive contact with the economics of building one? OpenAI was not founded to build products. It was founded to prevent a catastrophe. That distinction matters, and it was not accidental. When the organization launched in December 2015, its founding documents described a specific and deliberate purpose: to ensure that artificial general intelligence, if it arrived, would benefit humanity broadly rather than a small group of people who happened to control it first. The structure chosen to pursue that goal was a non-profit, not because non-profits are inherently virtuous, but because a non-profit cannot be purchased. It cannot be taken public. It cannot be steered by the financial interests of shareholders who want a return by a specific quarter. The structure was the point. Elon Musk was one of the original co-founders. He contributed approximately $100 million to the organization in its early years. The historical record describes his involvement not as a vanity project, but as a genuine expression of concern about what large AI systems, built entirely inside profit-motivated companies, might eventually do. He was not alone in that concern. The founding team included researchers and engineers who had left or turned down positions at Google and other major labs specifically because they believed AI development needed an institution that was not accountable to a stock price. Nobody loved OpenAI the way people love a product they chose, but the organization had something that mattered more than affection. It had credibility. Policymakers in Washington and Brussels referenced it. Safety researchers published alongside it. When OpenAI said it was prioritizing caution, people had structural reasons to believe that might be true. The non-profit model gave the mission weight that a press release never could. That credibility was built slowly and on a specific foundation. OpenAI published its research. It released model weights. It described its methods openly, which is where the name came from. The implicit contract with the research community, with regulators, and with the public was straightforward. We are not optimizing for profit, which means our conclusions about safety can be trusted more than conclusions from organizations that are. That contract would not survive contact with what it actually costs to build frontier AI. In 2019, OpenAI restructured. The nonprofit did not disappear, but it created something underneath itself. A new entity called a capped profit company, meaning investors could participate and earn returns, but those returns would be limited. The cap was set at 100 times the original investment. That number was presented publicly as a reasonable constraint, a way to attract the capital necessary to compete with Google and Meta while still preserving the mission at the top of the structure. This was not a business decision forced by economic reality. This was a philosophical reversal that economic reality made convenient. The distinction is worth sitting with. OpenAI's leadership argued that training frontier AI models required billions of dollars, and billions of dollars require investors, and investors require returns. That logic is not wrong, but the structure chosen to satisfy that logic did something specific. It created a class of people whose financial interests were now formally embedded in every major decision the organization would make. The mission did not disappear from the documents. It just now shared the room with something else. Elon Musk departed from OpenAI's board in 2018, roughly a year before the restructuring was finalized. The stated reason at the time was a potential conflict of interest with Tesla's own AI development work. The timing has been interpreted differently by different people, and Musk himself has described it differently at different times. What is not disputed is that he was no longer inside the organization when the capped profit structure was approved. He did not vote on it. He was not consulted in any documented way. He learned about the direction OpenAI was heading the same way most people did. The change was framed publicly as necessary and carefully designed. The people who left around that period called it something else. Several researchers who had joined specifically because of the non-profit structure quietly moved on in the years that followed. Their departures did not make headlines. Institutional drift rarely does, at least not while it is happening. What the 2019 restructuring actually set in motion was a new logic for every decision that came after it. If you need to raise capital to compete, and you have investors expecting returns, then the products you build and the speed at which you build them are no longer purely scientific questions. They become financial ones as well. That shift does not announce itself. It accumulates in choices that each seem reasonable in isolation and only reveal their pattern later. By the time Musk filed his lawsuit in 2024, he was not responding to a single decision. He was responding to 5 years of decisions that he argued, collectively, had turned the nonprofit mission into a legal fiction sitting on top of a commercial enterprise. Whether a court would agree with that framing was uncertain. But the underlying question, whether the structure change in 2019 broke an original promise, was one that the founding documents made genuinely difficult to dismiss. Musk's legal team filed the expanded federal lawsuit in February 2025. The filing did not come out of nowhere. It came from years of watching a restructuring unfold that he believed violated the terms under which OpenAI had been built. And it arrived at a moment when OpenAI was in the middle of negotiating what would become the largest private fundraising round in the history of the technology industry. The lawsuit alleged breach of contract and breach of fiduciary duty. At its core, the argument was straightforward. OpenAI had made specific commitments about its nonprofit structure and its obligation to develop AI for the benefit of humanity rather than for private gain, and those commitments had been abandoned without the consent of the people who had helped build the organization on the assumption that they would be kept. This was not a personal grievance dressed in legal language. It was a claim that a founding agreement had been quietly dissolved while the organization continued to use the credibility that agreement had generated. OpenAI's response was immediate and categorical. The company stated that the lawsuit was without merit, that the restructuring was legally sound, and that Musk's real motivation was competitive rather than principled. That he had built xAI, his own AI company, and that blocking OpenAI's for-profit conversion would benefit him financially while harming an organization he had chosen to leave years earlier. They did not offer negotiation. They did not acknowledge the underlying question the lawsuit raised. They refused to back down. The psychology of that response matters as much as its legal content. For the first time in the history of OpenAI as a public institution, it was not being asked to explain a product decision or a safety evaluation. It was being asked to justify its own existence as the thing it claimed to be. And its answer was to attack the credibility of the person asking. That is a different kind of response than a technical rebuttal. It is the response of an organization that has decided the question itself is not legitimate. Whether the legal theory would survive scrutiny in court was genuinely uncertain. Constitutional scholars and nonprofit law experts who reviewed the filings described the case as novel and difficult, not frivolous, but not straightforward. The specific question of whether a nonprofit's founding commitments create legally enforceable obligations against future restructuring had not been resolved clearly in prior case law. OpenAI's lawyers knew that. Musk's lawyers knew that. The lawsuit was never primarily about winning in a courtroom on the first attempt. It was about forcing the question into a venue where it could not be dismissed with a press statement. The public reaction split almost immediately along lines that had little to do with the legal merits. Those who had grown skeptical of OpenAI's safety claims over the preceding years treated the lawsuit as validation. Those who saw Musk as a bad faith actor, using legitimate grievances as cover for a competitive attack, treated it as noise. Both readings contained something true. That combination, a real grievance, a compromised plaintiff, made the conflict genuinely difficult to resolve cleanly and made it easy for both sides to maintain their positions without conceding anything. Whether the allegations would hold up legally mattered less than what they revealed about the deeper argument no one in the AI industry had been willing to have openly. Each of these decisions, taken alone, might have been explained away. Together, they described something. The Microsoft partnership was announced in 2019, the same year as the capped profit restructuring. An initial investment of $1 billion was framed as a research collaboration. By 2023, that figure had grown to a reported $13 billion, making Microsoft the dominant external stakeholder in an organization that had been founded on the premise that no single commercial interest should hold that kind of leverage over its direction. The partnership gave Microsoft exclusive cloud rights to OpenAI's technology through Azure. It embedded OpenAI's models into Microsoft's core products: Office, Bing, Windows. The organizations became, in practical terms, deeply entangled in ways that the original nonprofit structure had been specifically designed to prevent. Then came November 2023. OpenAI's board fired Sam Altman. The stated reason was a lack of candor with the board, a phrase vague enough to cover almost anything and specific enough to signal that something had fractured internally. Within 5 days, Altman was reinstated. The board members who had voted to remove him were themselves removed. The sequence of events was striking not because of the drama of it, but because of what it revealed about where actual power resided. The board, the nominal governing body of the nonprofit sitting at the top of the structure, had tried to exercise its authority. The response from investors, Microsoft, and a significant portion of OpenAI's staff made clear that this authority had limits that the organizational chart did not describe. The governance had failed. Not in a spectacular way, in a quiet, structural way that left no obvious person to blame. Meanwhile, the pace of product releases was accelerating in ways that safety researchers inside and outside the organization found difficult to reconcile with the stated mission. GPT-4 launched in March 2023. The gap between internal safety evaluation and public deployment was described by several people familiar with the process as compressed in ways that earlier releases had not been. OpenAI's own documentation acknowledged that frontier models could have capabilities that evaluators had not fully characterized before release. The acknowledgement was honest. The pace continued anyway. By 2024, reports of a full for-profit conversion were circulating with enough specificity that they were no longer rumors. Governance documents filed during the period described a structure in which the nonprofit board would retain oversight but would no longer control the commercial entity in any meaningful operational sense. The language was careful. The implications were not subtle. OpenAI. I was no longer a safety organization that built products. It was a product company that used safety language. That is not a cynical reading. It is what the structure described. The Microsoft dependency, the governance collapse in November 2023, the accelerating release schedule, the move toward full for-profit status. Each of these things had a reasonable individual explanation. Taken together, they formed a pattern that answered the question the 2019 restructuring had left open. The mission had not been protected by the capped profit model. It had been gradually subordinated to it. Whether any of this was illegal was a separate question from whether it was a betrayal of the original agreement. And that distinction, between legal and faithful, was exactly what the lawsuit was built around. What OpenAI released in the 2 years following its restructuring was not a research paper. It was infrastructure. By early 2025, ChatGPT had more than 300 million weekly active users. OpenAI's API was embedded in thousands of third-party applications, enterprise software systems, and government services. The for-profit conversion that Musk's lawsuit was trying to block had already, in practical terms, happened in everything but the final legal documentation. The non-profit shell at the top of the structure retained its name. The commercial entity beneath it had become one of the most consequential technology platforms in the world. This is where the story gets genuinely complicated, and where anyone telling it honestly has to hold two things true at the same time. The for-profit conversion unlocked things that the non-profit structure could not have funded. The scale of compute required to train frontier models is not a theoretical constraint. It is a physical one. Thousands of specialized chips running continuously for months, consuming electricity at industrial scale, housed in data centers that cost billions of dollars to build and operate. The nonprofit model, dependent on donations and grants, could not sustain that. The commercial model could, and the products that emerged from that investment, models that can write code, analyze medical imaging, translate between dozens of languages with reasonable fluency, are genuinely useful to a very large number of people. That is not nothing. But Elon Musk's own position in this story is not clean either. By the time his lawsuit escalated to federal court in early 2025, xAI, his competing AI company, had raised approximately $6 billion in its own funding round and was actively developing Grok, a large language model competing directly with ChatGPT. A legal injunction blocking OpenAI's for-profit conversion would benefit xAI commercially. It would slow a competitor's access to capital. It would create regulatory uncertainty that a smaller, newer company is better positioned to navigate than an established one with $13 billion of Microsoft infrastructure depending on its stability. Musk's grievance may be real. His financial interest in the outcome of that grievance is also real. Both of these things are true simultaneously, and the lawsuit does not require you to choose between them. What the conflict actually exposed is a divide that runs through the entire AI industry, not just through OpenAI. The question is not whether Elon Musk is a principled plaintiff or a strategic one. The question is whether it is structurally possible to build the most powerful AI systems in the world inside an organization that is also accountable to investors expecting returns, and whether the answer to that question changes depending on how powerful those systems eventually become. OpenAI says the answer is yes. The safeguards are built in. The mission is preserved at the governance level. The commercial structure is a delivery mechanism, not a replacement for values. Musk's lawsuit says the answer is no, and that the history of the past 6 years proves it. The question of who owns the future of AI is not answered by a lawsuit, but the lawsuit forced it into the open in a way that board memos and public statements had not. The detail that deserves its own attention, because it directly addresses what the lawsuit claims is impossible to separate, is the depth of OpenAI's integration into United States government infrastructure. In January 2025, OpenAI announced a partnership with the American government as part of the Stargate initiative, a joint venture involving SoftBank and Oracle with a stated commitment of up to $500 billion in AI infrastructure investment over 4 years. The White House announced it from the Roosevelt Room. The scale was not incidental. It was the point. OpenAI was no longer a research organization with commercial ambitions. It was, by early 2025, a piece of critical national infrastructure in everything but legal designation. That integration changes the nature of what Musk's lawsuit could realistically achieve, even if it succeeded on every legal argument it made. A court could theoretically block the for-profit conversion. It could require OpenAI to restructure its governance in ways that restore meaningful non-profit control. What a court cannot do is unwind $500 billion of committed infrastructure investment, reverse the embedding of OpenAI's models into federal agency workflows, or extract the organization from the Microsoft dependency that $13 billion of investment has created over 6 years. The structure is not just a legal document anymore. It is load-bearing. Remove it, and something significant collapses. Not the mission, but the architecture that the mission now depends on to function at scale. The problem was never the product. The problem was the structure that produced the product without the oversight the original mission required. This is not an argument for OpenAI's position. It is a description of the situation that OpenAI's choices created. The organization built something genuinely useful and genuinely consequential, and it built it in a way that made the original governance framework obsolete before anyone voted to change it. By the time the formal for-profit conversion was being finalized in 2024 and into 2025, the practical conversion had already happened years earlier. The lawsuit was, in a structural sense, arriving after the fact. Congressional attention followed. Members of both parties referenced the Musk lawsuit in hearings about AI governance and the appropriate role of non-profit structures in the development of dual-use technology. The EU's AI Act, which had been moving through implementation in parallel, added regulatory pressure from a different direction. Policymakers on both sides of the Atlantic were now asking the same question that the lawsuit had raised, not because of Musk specifically, but because the question had become unavoidable. Who is actually accountable for what OpenAI builds, and to whom? What happened next in the industry suggested that others were watching closely and drawing their own conclusions. The people watching this conflict most carefully were not investors or journalists. They were AI safety researchers, people who had built careers on the assumption that a well-structured, mission-driven organization at the frontier of AI development was not just possible, but necessary. Consider what the conflict looked like from inside that community. A researcher who had joined an AI safety team in 2021 or 2022, drawn partly by the credibility of OpenAI's stated commitments, was now watching the governance structure that underpinned those commitments be contested in federal court, while the organization continued releasing increasingly capable models on an accelerating schedule. The lawsuit did not change their daily work, but it changed the answer to a question they had been able to leave comfortably unresolved. Who exactly is accountable for what this organization builds? AI safety forums and research communities described a shift in the months following the lawsuit's escalation. Not panic. Something quieter. A recalibration of assumptions about which institutions could be trusted to hold the line on evaluation timelines, on deployment decisions, on the gap between what a model can do and what it should be used for. Several researchers who had previously spoken publicly in defense of OpenAI's governance approach became notably quieter on the subject. Independent developers felt it differently. The API pricing changes that accompanied OpenAI's fundraising rounds in 2023 and 2024 were a practical signal that the commercial logic was now fully in control of decisions that had previously felt more technical. Developers who had built products on OpenAI's infrastructure described the experience of watching pricing shift beneath them as a specific kind of vulnerability. The kind you feel when you realize the platform you depend on has interests that are not aligned with your own. Policymakers noticed too. Congressional testimony through 2024 and into 2025 referenced the Musk lawsuit not as evidence of a personal dispute, but as a symptom of a governance gap that no existing regulatory framework had been designed to address. The EU's AI Act had provisions for high-risk AI systems, but those provisions assumed the organizations deploying such systems had stable, identifiable governance structures. The contested nature of OpenAI's structure made that assumption difficult to apply cleanly. For ordinary users, the hundreds of millions of people using ChatGPT to draft emails, answer questions, help with schoolwork, the conflict was largely invisible. But it was not irrelevant to them. What the lawsuit surfaced, in terms they rarely had language for, was the question of whether the AI assistant embedded in their daily routine was being built by an organization with a coherent obligation to their interests, or by one whose primary obligation was to the investors who had made its existence possible. Most people had not asked that question. The lawsuit made it harder not to. Word of this tension did not travel through the usual tech news channels. It traveled through academic conferences, through developer communities, through the quieter professional networks of people whose work depended on having a reasonably clear answer. What Microsoft, Google, and every other major AI lab did next made clear they were paying close attention. The broader industry consequence of this conflict is already visible. It is not the lawsuit itself that changed things. It is what the lawsuit forced into the open. Within months of the federal filing, Google DeepMind published an updated framework for its internal AI safety governance, with language that was notably more specific about board oversight than anything the organization had released previously. Anthropic, which had structured itself as a public benefit corporation from its founding, in part as a deliberate response to the governance ambiguities at OpenAI, found its own structure cited in regulatory discussions as a potential model worth examining. Neither of these things happened because of Elon Musk. They happened because the lawsuit had made the governance question impossible to treat as settled. OpenAI's structural inability to resolve the trust problem is not a failure of intention. It is a consequence of the architecture. The investment is too deep to reverse. $13 billion from Microsoft, infrastructure embedded in federal agencies, a product used by hundreds of millions of people. These are not things you unwind because a court filing raises uncomfortable questions about the 2019 restructuring. The nonprofit mission still exists in the documents at the top of the structure. but the commercial entity beneath it has obligations to investors, to enterprise customers, to government partners that now take precedence in any decision where they conflict with the slower, more cautious logic of a safety-first research organization. Removing those obligations would mean removing the capital that makes the entire operation possible. There is no version of that conversation that ends well for the people who depend on OpenAI's continued solvency. Musk's structural inability to win through litigation is equally real, though less discussed. The legal theory is contested. The commercial conflict undermines his standing as a disinterested plaintiff, and even a favorable ruling would not restore what he says was lost. It would simply create a new governance structure on top of an organization that has already grown well beyond the point where governance documents alone determine behavior. Courts can change structures. They cannot rebuild trust that was spent over 6 years of decisions that each made sense at the time. What the conflict revealed is something the AI industry had been careful not to say plainly. The combination of frontier AI development and for-profit corporate structure creates pressures that existing governance frameworks were not designed to contain. The nonprofit model could not fund what needed to be built. The for-profit model cannot be fully trusted to constrain what gets built with that funding. Both of those things are true. Neither side in this lawsuit has a solution to the problem they are describing. They only have competing versions of who is to blame for it. The broader question, whether safety and scale can genuinely coexist inside a structure accountable to investors, is one the entire industry is now living inside, not just OpenAI. Google, Meta, Amazon, Microsoft, and every well-funded AI lab is operating under some version of the same tension. The Musk lawsuit named it. It did not create it. When the structure that produces the technology cannot be held accountable to the values that justified building it, what exactly are we supposed to trust?